Welcome, everyone. Thank you, Renu, and welcome everyone to today's webinar presentation, What to Expect with New Drug Testing and Marijuana Legislation in 2022, which will require a look back at 2021. And I strongly encourage and invite you to submit any questions that you have, anything that you'd like to know about anything we discussed today, as well as any other drug testing related questions or issues. I'm happy to address those for you. I want to also just acknowledge Orange Tree for putting on these monthly webinars. It's just so important to be providing and sharing information. There's still a lot of fallout from the impact of COVID on the drug testing world, whether you're a buyer of drug testing or a seller of drug testing. And so these types of webinars are critical to just sort of keeping us all in the loop in terms of what's going on. We do a survey every year at the Current Consulting Group, an industry survey and an employer survey. And Orange Tree, we're very grateful to Orange Tree for being a sponsor of our employer survey. But those surveys provide good information about what's going on in the drug testing industry, or in the from a buyer perspective or from a seller perspective. And these types of webinars make it possible to share that information so we can all make good, solid, and educated, informed decisions. So hopefully from today's presentation, you'll get a little bit of information about that will be helpful to you. Of course, we're going to talk about new laws and I've added 2022 to the description here in the agenda because we had some new information come out just this morning that I hurried to put into the slide deck. Renu hasn't even seen these two slides that I'm adding in. But we'll talk a lot about what happened in 2021 because that's really what's unfolding in 2022, the things that were passed last year that are being enacted this year. We'll talk specifically about New York. As many of you may know, New York became the first state to prohibit testing for marijuana, pre-employment, existing employees, etc. However, there are a few loopholes in the marijuana law. So I'll discuss those in detail and answer any questions that you have. We'll look a little bit at bills that failed in 2021 because those are the same ones that will be coming back around in 2022. And then we'll talk a little bit about the future, what to expect this year. And we'll talk in more practical terms about how to address these issues in your drug testing policy. And I'll talk a little bit about some ROI issues that I threw in at the end there to round out our discussion today. So let's talk about new laws passed in 2021. There was, of course, marijuana legalization bills passed. There was very popular right now, what we call marijuana discrimination laws. I'll explain what those are and give you some examples from 2021. Other cannabis-related bills that passed, other drug bills that passed, not just cannabis, but other types of drugs as well, and drug testing specifically, and then a few defrauding a drug test bills that passed in 2021. So when we look at 2021, we think in terms of the states that legalized marijuana or expanded the legalization of marijuana. So there was New Jersey, New Mexico, New York, Virginia, and Connecticut. As you can see at the bottom of each of those states, these were states that either passed or significantly expanded their recreational marijuana laws. And by recreational, I mean the recreational use of marijuana as opposed to the medicinal or medical use of marijuana. And so about 19 states, including the District of Columbia, have legalized the recreational use of marijuana. The sort of politically correct term is adult use of marijuana. However you slice it, however you term it, the semantics of it, the bottom line is that it's legal to use marijuana for any purpose or no purpose at all in these states, as well as many others that have passed their laws. And in fact, I'll show you a map here in a minute that kind of shows you the lay of the land for the legalization on a state-by-state basis. But let's go to 2022 so far. So every month, the Current Consulting Group puts out a legislative update on anything that could affect drug-free workplace programs, drug testing, certainly these marijuana laws, et cetera. And so we just put one out this morning. And so I would have a lot more on these states that you're going to see here: Delaware, DC, South Dakota, and on the next slide, Mississippi. If it hadn't been for the fact that all of this just happened today. But I wanted to put a little information in there so we don't ignore these most recent developments. Now, Delaware is an amendment to the drug testing language in their existing law, and it basically amends the drug testing requirement for applicants and employees of the Department of Services for Children, Youth, and their Families. So this may not apply to very many people on today's webinar, but it's significant in that it gives you a flavor of what the legislative attitude is in the state of Delaware when it comes to drug testing. This is not a marijuana specific amendment, but a drug testing specific amendment. And these types of things are not uncommon when you'll see a law or a regulation passed that applies to a specific government entity. But again, it shows you a little bit of the sort of mindset in a state when it comes to drug testing. So in DC, however, an existing medical marijuana law was amended to allow senior citizens 65 and older to self-certify that they're using cannabis, marijuana for medical purposes. That's a slight change to the way the law read before, where there was a requirement to sort of verify the use of marijuana for medicinal purposes. Now seniors can self-certify. In South Dakota, now this would require more explanation than we have time for today. Maybe we can come back to this and talk about it at a later date. But South Dakota amended a medical marijuana cannabis law that already existed and defined safety-sensitive jobs and under the influence of cannabis. So those two terms are now defined in the South Dakota medical marijuana law. This is significant in that many states passed marijuana laws, whether medical marijuana or recreational marijuana, and they'll place some restrictions or conditions on employers, but they won't define the terms. So what does safety sensitive actually mean? I'll give you a perfect example of this. Now, New York's changed, okay, from one, well, let me not say New York. Let me use Philadelphia as an example. So Philadelphia, the city of Philadelphia, passed a city ordinance that prohibits testing for marijuana on pre-employment tests. So employers within the city of Philadelphia cannot test applicants for marijuana, except for a list of safety-sensitive occupations or jobs. Initially, those types of jobs were not clearly defined, but now Philadelphia, following the example of New York City before, has defined what those safety-sensitive jobs are. Some of them are somewhat broad categories like drivers, et cetera, commercial drivers, versus police officers, firefighters, et cetera. So sometimes states or municipalities will pass these laws or city ordinances without really defining the most important pertinent terms. For example, what does under the influence of cannabis mean? Many states use some terminology like that, under the influence, or they'll even go so far as to say impaired or impairment, but they won't define what that means. And it's a very open-ended issue if you don't define these terms. Now, South Dakota's gone back and they've defined safety-sensitive job and under the influence. And you may see other states follow that lead and do the same thing. Illinois is a good example of a state that has some very misleading terminology in its marijuana laws that leaves a lot open to interpretation. This is dangerous for employers because you may interpret incorrectly and find yourself in a little bit of legal trouble. But South Dakota has clarified at least these two terms in addition to others that are included in their definitions. And that may be an example followed by other states. Now, we're going to spend a little bit of time on Mississippi. Now, Mississippi voters originally voted to legalize marijuana in the state. And then through a technicality that was sort of thrown off and put on hold. Now the Mississippi medical marijuana law is in place, and now some additional language has come out that is specific to the workplace. as we track these laws at the Current Consulting Group, and as we provide information to Orange Tree, for example, we're really just, focusing on workplace related issues. So let me take you through these 4 bullets. There's a whole lot more to the Mississippi law than just these 4 bullets, but let me emphasize these 4 things, and note that each of these bullets starts with the words does not require, does not prohibit, does not affect. So we're going to look at Mississippi from the perspective of an employer, and I'm going to just tell you right off the bat, this is a good law for employers. Many medical and recreational marijuana laws include workplace-related language that's very restrictive and challenging for employers to comply with. Illinois is a very good example of that. I'll pick on Illinois because they're one of the most restrictive sort of anti-employer marijuana laws. Not as restrictive as New York, which we'll talk about in detail later. But in Mississippi, we would consider this to be an employer-friendly approach to marijuana legalization. So the first bullet does not require any employer to permit, accommodate, or allow the medical use of medical cannabis, or to modify, this is important, to modify any job or working conditions of any employee who engages in the use of medical marijuana. This is important because there are some states that require employers to make certain specific accommodations for medical marijuana users. In Mississippi, they were very careful to say the employer is not required to permit, accommodate, or allow medical marijuana use, even for those who are legally registered to use medical marijuana in the state of Mississippi. Second bullet, the Mississippi law does not prohibit any employer from refusing to hire, discharging, or disciplining an individual with respect to hiring, discharging, tenure terms, conditions, or privileges of employment as a result of that person using medical marijuana. This is also important because many states that have legalized marijuana say just the opposite. Mississippi gives the employer the latitude to still decide on a policy basis, in that company's policy, that they will not hire people, or they're not prohibited, let's say, from refusing to hire or discharging somebody. Now look at the third bullet. This is important also, that in Mississippi, the law does not require a workers' compensation insurer or self-insured group to pay for or reimburse the cost of medical marijuana to a registered medical marijuana user. We don't see a lot of laws opposite to what this says, but there are some, like New Mexico, where employers are required to pay for or reimburse as the use of medical marijuana in the same way that their insurance provider or healthcare provider might reimburse for any other type of medication. Mississippi says no, nothing in this law requires that provider, that insurance provider or self-insured group, to cover these costs. And then the fourth bullet, the Mississippi law does not affect an employer's right to deny or establish legal defenses to the payment of workers' compensation benefits for somebody who tests positive. This is important because in many states, in most states, there are workers' compensation and unemployment compensation regulations already in place that allow employers to move to deny workers' comp or unemployment comp benefits to an individual who tests positive. In other words, if they were terminated, or if they are filing a workers' comp claim on an accident that they then tested positive for drugs later, then in most states, the employer has a right to move to deny benefits to that individual. In Mississippi, they're saying as part of the medical marijuana law, nothing affects the employer's right to do that. So this again is employer friendly from that perspective. And I just wanted to spend a few minutes on these new developments in 2022 before we go into 2021. And this is what the map looks like now. So the orange states are the recreational or adult use marijuana law states, where it's legal to use marijuana regardless of, well, for any reason at all. The blue states are the medical marijuana laws states. The white ones are no marijuana legalization, at least up to this point. And then South Dakota, which I'll mention in a minute. Now, all of the orange states, the recreational marijuana states, where it's legal to use marijuana for any purpose at all of those states already include the legalization of medical marijuana use. So they, in almost every instance, they started with medical marijuana legalization and they moved to recreational marijuana down the road. The legalization of marijuana, as you can see, is spreading across the country. Many of the states in white have already decriminalized the possession of marijuana at one level or another. So it's not as if the white states have not legalized or made it easier to use or possess marijuana in any way at all. In fact, there are really only 2 or 3 states that have just held their ground entirely on either the legalization of marijuana or the decriminalization of the possession of marijuana. So the chart, as you see it here, might give the impression that half the country is still holding out, and that's not actually true. Almost every state is acquiesced in one way or another to the legalization movement, and the orange states have gone all the way to basically remove any restrictions to using marijuana. Even in those orange states where marijuana use is legal and for 21 and older, you see that there's really no consequence for people under the age of 21 using marijuana on a recreational basis. So let's look at a few things that happened in 2021. And as we go through that, that little bit on 2022, start keeping track of your questions, because I'm sure you're going to have a few, and I'd be happy to address those as well. Towards the end, I'm going to make a couple of predictions about 2022. So we're not done with 2022 yet. And of course, as I mentioned, these 2021 developments are important because they're going into effect in 2022 in many cases. Okay, so in Alabama, medical marijuana was legalized. Now, look at the second bullet. This again is sort of an employer-friendly approach. An employer is not restricted in refusing to hire an individual who uses medical marijuana and is permitted to take adverse employment action, including discharge against an employee for the use of medical marijuana, regardless of the individual's impairment level. So in many states like Illinois, I'm going to pick on Illinois a lot, there is language in their legal marijuana law that requires an employer to prove that an individual was impaired by marijuana in addition to a positive drug test result before the employer can take adverse employment action against that individual. Say, for example, you cause an accident, the company conducts a drug test, you test positive for marijuana, you can't take action against that employee in Illinois until you can also somehow prove that the individual was impaired at the time of the accident. Well, drug tests don't prove impairment, and in some states, they've actually included language that says you can't use a positive drug test result as justification for taking adverse employment action. So now you're going to have to resort to, excuse me, to some other form of proof, maybe written documentation, sort of outlining the aberrant behavior of the individual, the increased accidents, tardiness, absenteeism, various things that would have maybe triggered a reasonable suspicion test at some point. Or you may turn to non-drug testing related fitness for duty or impairment testing systems, pupillary exams, or cognitive, like computer-based cognitive testing to determine whether somebody's impaired regardless of the reason. I think we'll see a lot more of that in the future as well, because many states are going to go the way of Illinois versus Alabama, but in Alabama, an employer-friendly approach to that issue. In DC, this law only applies to public employers, okay? A public employer may not refuse to hire, terminate, penalize, fail to promote, or take adverse employment action against someone based upon their status as a qualifying medical marijuana patient. And this does not apply if the individual used, possessed, or was impaired by marijuana while on the job. So there is a caveat there to protect the employer, but again, they would have to prove somehow that in addition to a positive drug test result, the individual was impaired. But generally speaking, and this is public employers, so government, DC government employers, they can't really do much about an individual in terms of hiring or terminating or penalizing them anyway, simply for being a registered medical marijuana user. There's a little bit more on DC. Like, for example, look at that first bullet. A patient's failure to pass a drug test due to marijuana components or metabolites may not be used as a basis for employment-related decisions unless reasonable suspicion of drug use exists and there was some reasonable belief and proof that the individual was impaired in the workplace. So why is this important? Why are we talking about it? Maybe none of you do business in DC, or you're not a government entity in DC, probably not. But these types of bills, this type of legislation becomes sort of a template for legislation that will be introduced in other places. And so DC is, I'm not going to say it's employer friendly, it's not, but it's a little bit more reasonable than what you would see in a state like Illinois, New Jersey, New York, etc. But not entirely employer friendly. And so we may see this as a sort of a template used by the legalization movement in other states or municipalities. Montana requires a little bit more discussion. Okay, so employers cannot take adverse employment action, including follow-up testing, if the employee presents a reasonable explanation or medical opinion that the test results, positive test results, were not abused by the illegal use of controlled substance or by alcohol consumption. Because marijuana use is legal in Montana, it would not be considered illegal use. That's going to affect what employers in Montana can do. And this is a little surprising for Montana because they tend to sort of lean toward the conservative way of looking at things. And yet this is a little bit more of an employer unfriendly approach. Look at the second bullet. Employers cannot refuse to employ or discriminate against an individual because the individual legally uses a lawful product, marijuana being a lawful product in the state of Montana, except the use of that lawful product, marijuana, on the employer's premises. So if they're doing it on their own time outside of the workplace, the employer really has no recourse. That doesn't mean that the employer has to accommodate impairment in the workplace. So that's a caveat that applies in Montana. If you're a Montana employer, you may know more about the development of this than I do, but we're going to keep an eye on Montana because I can see a legal challenge to the wording of the Montana law at some point in the future. So I don't think the Montana book is closed yet on this particular issue. Connecticut tends to be a more liberal state, and the more liberal states, and this is not a political statement on my part, but the more liberal states politically tend to be much, much more lenient toward marijuana use. That's true in the Northeast, as well as on the West Coast with California, Oregon, Washington, and even Colorado. So in Connecticut, like marijuana description laws, but not passed as a separate law. It's included in the law. No employer may refuse to hire, discharge, penalize, or threaten an employee solely on the basis of their status as a qualified medical marijuana patient. Now, we're going to see that term qualified medical marijuana patient in many states. What does it mean? It means that that individual must be registered to use medical marijuana in the state. Keep in mind that marijuana is still a Schedule I controlled substance under the federal law, which means just like heroin and cocaine, marijuana cannot be prescribed by a doctor. Now, you may be thinking, wait a minute, I thought that medical marijuana could be prescribed by a doctor. Legally, no, but doctors can recommend it. And so they can sometimes recommend it in writing or verbally, and that can be used to get to register as a medical marijuana user. And that's what it means to be a qualified medical marijuana patient. Employers can, however, prohibit the use of marijuana during work hours and discipline an employee for being under the influence of marijuana while at work. What does under the influence mean? Connecticut's a good example of not defining what that means, as opposed to what we saw in South Dakota earlier. In Mississippi. So we're going to see more of this being pushed to the forefront, where states are going to be forced to define what it means when they put in their law either impaired or under the influence. Now, the fourth bullet is significant here in Connecticut. Nothing limits an employer from taking appropriate adverse or other employment action upon determining that an employee manifests excuse me, specific articulable symptoms of drug impairment while working. Excuse me. So this is something that we'll see even more of in the future. This terminology, articulable symptoms of drug impairment. We're going to see that in the New York law that we're going to talk about. This is a trend, and it's a trend that will continue. A little bit more on Connecticut, just for your perusal. You'll have access to all of these slides in the recording of today's presentation. New Jersey, similar to marijuana discrimination laws, but again, not passed as a separate law. Here again, they're protecting the marijuana user from discrimination simply because they're a marijuana user or registered or qualified medical marijuana user. I do want to point out the second bullet though, because you don't see this in every marijuana law. Recreational cannabis is to be regulated the same as legal cannabis. That's an interesting clause to put into the New Jersey law, because one of the arguments of the pro-marijuana people is that marijuana and alcohol should be treated exactly the same because they're basically the same, they have the same effect on people. Well, that's not actually true. And I just actually wrote a paper on the ways in which alcohol and marijuana are alike and are not alike. And it's really interesting because of the health effects of alcohol and marijuana on the body, on the liver, on the pancreas, on the brain are very similar and very destructive, but they're very different in other ways. For example, alcohol, or I should say alcohol abusers or alcoholics, are considered a protected class under the Americans with Disabilities Act, whereas current drug users, keeping in mind that marijuana is still a Schedule I controlled substances under federal law, they do not enjoy the same protection under the ADA as alcohol abusers. And that's a huge difference because the Equal Employment Opportunity Commission, the EEOC, which regulates ADA issues, basically discourages employers from doing any kind of testing for alcohol that's not reasonable suspicion or for cause related. This is separate from any DOT regulations or the like, okay? But because drug abusers, current drug abusers, are not a protected class, the EEOC does not say the same thing about drug testing, pre-employment, or random as they do for alcohol testing. Just one of the different ways in which, or one of the many ways in which you can't really treat marijuana and alcohol exactly the same. Now here's a catch-all, couple of catch-all slides coming up. Just some other cannabis-related laws that passed in 2021. California permits industrial hemp to be included in products, including food, also authorizes cultivation and distribution of cannabis for research purposes. This is something regulated by the Drug Enforcement Administration. Delaware allows nurse practitioners and physicians' assistants to recommend medical marijuana. Look at the language there, right? They don't prescribe, they can only recommend. Florida removes provisions concerning scheduling of certain drug products containing cannabidiol. That's significant. Cannabidiol, a whole different issue and an interesting webinar to do at some point, because cannabidiol contains THC. And if you're a regular daily user of CBD oils, for example, you've got enough THC in you to trigger a positive drug test result. The challenge and the problem with that is for the user is that the laboratory can't distinguish where the THC came from. Did it come from a joint or did it come from CBD oils? You're going to test positive either way. And that's going to put the employer in an awkward situation when that individual comes forward and says, hey, I have a legitimate excuse, but they're not going to have any way to prove that they're using CBD oils instead of smoking pot. Florida removes provisions concerning scheduling of certain drug products containing cannabidiol. Mississippi authorizing dispensing possession or use of cannabidiol oil for debilitating epileptic conditions or other related illnesses. And Tennessee created a medical cannabis commission to look at the whole issue, generally speaking. Many states have done that as well. Also, New Jersey reclassified possession of psilocybin as a disorderly person's offense. So they've essentially lowered the legal consequence for possession of psilocybin or magic mushrooms. This is something that's spreading across the country. The many states, DC is a good example, Oregon's another example, where they have gone out of their way to either legalize the use of psilocybin or magic mushrooms, or to remove legal penalties for possession and use of psilocybin. So we're seeing that across the country. Hawaii requests the Department of Health convene a working group to examine medicinal therapeutic effects of psilocybin. Okay. Maine removes the definition of drug trafficking from the possession of specific weights or amounts of drugs. This is a movement toward either decriminalizing or legalizing many other drugs besides marijuana, something that Oregon has already done. Rhode Island reclassifies simple possession of 10 grams or less of a controlled substance in Schedules 1, 2, 3, 4, and 5 of the Federal Controlled Substances Act to a 2-year misdemeanor instead of a felony. This, again, is another movement toward the legalization of all drugs. If you go back and look at the sort of the legalization talking points from the 70s and early 80s, it wasn't just about legalizing marijuana, it was about legalizing all illicit drugs, cocaine, heroin, etc. Part of their argument was that back in the turn of the 20th century, in the 1900s, cocaine and heroin were legal products that could be prescribed or dispensed by a pharmacist. And then, of course, all of that changed. Then there was no appetite for that. So the legalization moved just to focusing on marijuana. There was no appetite for that either. So then it moved to legalizing the use of marijuana for medicinal purposes. And then they sort of struck a chord with the compassionate nature of most Americans. And they found an inroad. And now they've just been expanding it not only to marijuana and recreational use of marijuana, but to many other drugs. The ultimate objective is to legalize all drugs or to decriminalize heroin, cocaine, et cetera, which Oregon became the first state to do that for all drugs. And as you can see, Rhode Island took a big giant step in that direction as well. There were a couple of drug testing related law bills that were passed last year. Arizona now requires drug and alcohol testing of school bus drivers, right? Hard to believe they didn't require that already. And the District of Columbia clarified that public schools shall not require volunteers to take a drug test, other than a test required because of a reasonable suspicion scenario. So again, sort of loosening up the environment there. And then a number of states passed drug test cheating laws. So Iowa creates a criminal offense for defrauding a drug test or an alcohol test for workplace purposes. Mississippi prohibits the sale of urine for purposes of defrauding a chemical test, like synthetic urine, for example, which is very popular. And then you see in New Hampshire prohibits the manufacture, sale, distribution, marketing, or possession of synthetic urine or urine additives, and prohibits attempts to defeat or defraud a drug test with the use of these products. There are now several states, like Texas, for example, that have these drug test cheating laws, or might better be termed an anti-drug test cheating law. And I think we'll see a little bit more of that in the future. Now, let's turn our attention to New York. Hopefully you're writing down your questions. You may have some more after we talk about New York. I'm going to say that New York has taken things to a whole new level in terms of restricting or placing onerous conditions on employers when it comes to drug testing for marijuana. Now, many companies have decided to drop marijuana from the drug test panel. As part of the Current Consulting Group annual survey of employers, we saw a significant increase between 2020 and 2021. We saw an increase in 2020 in our survey, but we sort of attributed it to the effects of COVID. But the trend continued in 2021. And so now we're seeing a real movement toward employers taking marijuana out of their drug test panel. And I'm sure if Ray New and I had a few minutes to talk, there are probably some Orange Tree clients that have done the same thing. If I were in the business of testing for marijuana only, if that was what my whole business model was, I would get into a new line of work, because I think we're going to see that trend continue. And part of the reason why I make that prediction is because there's a lot of misinformation about what employers can and cannot do when it comes to testing for marijuana. But part of the reason I make that prediction is because of what happened in New York in 2021. New York had already passed medical marijuana and then recreational marijuana by decree of the governor. The Department of Labor was then authorized to come up with guidelines for drug testing for marijuana in the workplace. And they issued those guidelines towards the end of 2021. And we were shocked when we saw them, because essentially, if you read these guidelines just on the surface, you can't test for marijuana in the state of New York. And I had somebody come to me the other day recently and said, well, in New York City, it's just pre-employment testing for marijuana that's prohibited. Well, the New York state law preempts the New York city law. And so the restrictions contained in the New York state law they trump the New York City language in its city ordinance. So now in the state of New York, regardless of what city you're in, you can't test for marijuana. Now, I'm going to add a big giant caveat to that in a second, okay? But look at the third bullet down. Employers cannot refuse to hire, employ, license, discharge, or otherwise discriminate against an individual because of their use of legal products. And marijuana is legal in the state of New York. Next bullet down. Employers cannot require employees or applicants to agree to abstain from cannabis use as a condition of employment. Think about any number of safety-sensitive jobs. Individuals who carry firearms for a living, who run into burning houses and buildings for a living, or operate heavy machinery or drive trucks for a living. You cannot require them to abstain from using cannabis. But this does not apply if an employee is impaired by cannabis use on the job. There's still a little bit of wiggle room, maybe not on the testing side so much, but in the idea of coming into the workplace impaired by marijuana. Now, let's move to the next slide. Employers can take employment action against an employee if the employee is impaired by cannabis at work. The problem is you can't test for marijuana. So how do you prove impairment? And what is impairment? Well, New York attempted to define impairment in the worst possible way. They really dropped the ball on this because they defined it as an individual in question manifesting specific articulable symptoms of impairment that decrease or lessen job performance or interfere with the employer's obligation to provide a safe and healthy workplace. That could be a lot of different things. That language opens employers up to all kinds of legal challenges, okay? Look at the next bullet though. Neither the Act or the Drug Testing Legalization Act or the Department of Labor guidance offers a list of symptoms of impairment. Rather, employers should look for symptoms that are objectively observable. Okay, that's our guidance. That third bullet there is Bill Current talking to you. But the fourth bullet, quote, says, observable signs of use that do not indicate impairment on their own cannot be cited as articulable symptoms of impairment. And now that leads to the final bullet. An employer cannot use a drug test as the basis for their determination that an employee was or is impaired by cannabis. Now, if you look at the New York law a little closer, you'll see that there's a little bit of wiggle room for possibly claiming that an individual is impaired on the job. There's a lot of prohibitions, as you see on this slide right here, when it comes to the use and possession at work, okay? And I'll leave you to go through this in more detail so that we get to our discussion of policy and ROI. But on this next slide, I think that there's a little bit of wiggle room when it comes to reasonable suspicion and possibly post-accident testing. You may not want to be the employer who becomes the legal guinea pig for that, but I think there's room there. But here's my concern, which is that I think a lot of other states that have a tendency to be more restrictive when it comes to employers' rights and the issue of marijuana are going to use New York as sort of a template again for amending their marijuana laws to be more restrictive in the same way that New York has done. New York law already existed, and then these Department of Labor guidelines came out. I think New York will become the model for many other states. I think there's still wiggle room, okay? But we don't have any legal precedent to claim that. I have two attorneys who work for me here at the Current Consulting Group, and their position on this is we've got to wait and see. We think there will be some legal challenges, but we just don't know what those are going to be quite yet, okay? So much more to come when it comes to New York, but the news not good on the surface. Okay, I'm gonna breeze through this next section, bills that failed in 2021. But the reason why I'm going to mention them is that these are the same bills that will come up in 2022 or in 2023, depending on your state's legislative season. Okay, so states where recreational marijuana legalization failed: Florida, Mississippi, North Dakota, Maryland, Missouri. Okay, if you're in those states, you may already have noticed legislation being introduced this year. States where medical marijuana legalization failed, which is very rare: Tennessee and Mississippi. But we can actually, let me amend that. I should have updated that. Mississippi, we can take that off the list now because Mississippi was in my opening remarks. States where marijuana discrimination laws failed: Florida, Montana, Maryland, Tennessee. We'll see more of that in the future. Again, these are marijuana laws that already exist where they're adding anti-discrimination law language, meaning the employer can't discriminate against an individual for being a qualifying registered medical marijuana user. States where legalization of retail sales of marijuana failed: Louisiana and Florida. That also will change in especially in Florida where I live. We can already see that, coming about. Other laws that failed: Florida legalization of psilocybin for mental health treatment. Again, this is kind of like the medical marijuana movement, where it's like, if we can't get psilocybin legalized generally, can we do it for mentally ill people? Well, it failed in Florida last year. Mississippi, let's just take that off of there altogether. Montana delayed implementation of recreational marijuana laws for 1 additional year. As I said earlier, remember, I think Montana is going to change. I think there'll be some legal challenges to that. Nevada authorizing oral fluid testing for DUI. That's important to see that, even though it's not a workplace related market, but it's an indication of the mindset again in the state of Nevada, which has incidentally a somewhat restrictive drug testing law when it comes to marijuana. Okay, what to expect in 2022? So some of this doesn't take a brain surgeon to predict. Okay, more marijuana anti-discrimination laws will pass in 2022. More marijuana use by employees absolutely will be the effect of these very liberal, lax, and legal marijuana laws. More positive drug test results. Yeah, absolutely. We saw one laboratory, Quest Diagnostics, issued their annual drug testing index. We saw an increase in marijuana positive drug test results and other drugs as well. One drug testing provider that specialized more or less in the transportation industry showed a 400% increase in positive drug test results for synthetic opioids. Now, that's not, a level as high as marijuana positives, but it had a much higher percentage increase. And so during COVID, we saw a lot more use of opioids and amphetamines, for example, in addition to marijuana. Marijuana generally went up about 20% as a result of, or since the start of COVID, let's put it that way. The use of opioids skyrocketed. And of course, many of you have probably seen headlines in the news about opioid-related drug overdoses and fatalities. That's crept into the workplace in terms of more people testing positive for opioids. I think you should still test for marijuana, but you definitely should test for these other drugs as well, because they're equally, if not more so, impairing on the individual who uses them and is under their influence when he or she shows up to work. And then my final prediction: more need to show impairment and or recent use of marijuana. That's just going to become a thing. You're going to have to show some kind of documentation to take action against an individual who tests positive for marijuana in many states. That's already legally required in Illinois, for example, but it's going to spread throughout the country. And so that's where I think you're going to see more recent use drug detection type of testing and more fitness for duty, non-drug testing type of evaluations. But let's just look at three common drug testing methods. Well, two common drug testing methods and one new one. So urine, oral fluid, and breath. With urine testing, you're detecting a metabolite of the drug as opposed to the drug itself. So the body requires several hours, 5, 6, 7, 8 hours, to metabolize that drug that's gone into the system before it's detectable in urine. So for the first, let's say 7 hours, as you see here on my graphic, you're not going to be able to detect that drug in a urine test. It's just not, the body hasn't had time to metabolize it yet. But from then on, it's going to cover the entire window of impairment when it comes to marijuana. Well, what do I mean by window of impairment? A study came out over the summer last year from the University of Sydney, where they looked at 80 different reports on marijuana impairment or the impairment effects of marijuana. And they came to the conclusion that the window of impairment for marijuana use is between 3 and 10 hours. In other words, somebody remains impaired by marijuana, either their psychomotor skills or their cognitive skills, for up to 10 hours, longer in some cases, depends on a lot of factors. How often the person uses marijuana, the THC potency of the marijuana, which is much stronger today than it was back in the 70s and 80s, the way in which the drug was consumed, edibles versus smoking marijuana, and the task that's being asked of the individual. Are they being asked to remember instructions or operate a forklift? That will have a direct impact on what type of impairment they're experiencing, but that impairment is going to last on average 3 to 10 hours. So with urine, you're going to miss the first 7 hours of that individual being impaired, keeping in mind that impairment and intoxication are two different things. The high from marijuana will wear off after 30 minutes, let's say, but the impairment can last for up to 10 hours or longer, but let's conservatively say between 3 and 10 hours. Oral fluid testing detects the parent drug, not just a metabolite. So because it detects the parent drug, the drug becomes detectable in an oral fluid sample almost immediately after the person ingests the drug. And it can detect the drug for the entire 3 to 10 hour window of impairment. So you're not going to miss any legitimate positive drug test results of a person who's impaired by marijuana. With breath, which is a fairly new technology that I don't believe is going to catch on, but there are some companies that are making progress with. There's a company up in Canada, Cannabix, I think, that's having a lot of success with their technology. But I think all of it's a little bit of a ways off, and there are no federal regulations to guide you in it, or FDA cleared devices or labs, et cetera. But all of those things to the side. The window of detection with breath and detecting marijuana is about 3 hours. And so 2 to 3 hours, let's say. So you're going to catch the recent drug use impairment, but you're going to miss 70% of the people who legitimately may be impaired on the job from marijuana use. It just depends on what you want to detect. If you're not concerned about recent use detection, go with urine. If you're not concerned with the lingering impairing effects of marijuana, go with a shorter window of detection testing method. But if you want to catch all of the legitimate positives for individuals who are legitimately impaired while on the job, then you're going to want to look at oral fluid testing. And I think we're going to see a lot more of that in the future. That's my prediction. We saw a dramatic increase in the number of companies looking at or using oral fluid testing between 2019 and 2021. So I think that's going to continue to grow in market share. I think the increase in legalization of drugs other than marijuana will also continue in 2022. The legalization or decriminalization or reducing of criminal penalties. I think we'll see a lot of that in the future. And let me say, the New York law will have an impact as well. That may be something that pushes people toward breath THC testing, because they're just going to want to know those first 2-3 hours after somebody's using. Maybe they don't want to know the whole window of impairment ability. So that may push them towards testing methods where they're just getting a real short snapshot in terms of individuals who are on the job impaired. I think I'm in favor of all technology that can detect drugs, and there's a place for all of it to some extent. Just make sure that, you know, from a policy perspective, you've made sure that it's legal to do that type of testing, whether it's urine. Well, urine's legal in every state, oral fluid testing almost legal in every state. To make sure that, you know, you understand what the applicable laws require of you in those states, and that you update your policy regularly, especially if you're using a testing method other than urine. Urine, very accepted, part of the federal regulations. The Substance Abuse and Mental Health Services Administration in October 2019 did issue final guidelines for lab-based oral fluid testing. Most states allow it, just Vermont, Maine, and Hawaii do not allow lab-based oral fluid testing. I think that will change now that there's federal regulations. And the rumor on the street is that DOT is about to issue its oral fluid drug testing regulations at any time. So be aware of those laws and those regulations, and make sure your policy reflects the, you know, best way to do things, best practices, standard procedures that will increase the legal defensibility of your program. Treat marijuana intentionally in your program, in your policy. Don't think that you can skip past it, and know what the laws say in the states where you're doing business. But don't let these changing laws scare you away from drug testing or testing for marijuana. It's not accurate to say that employers do not have the right to test for marijuana. In every state, with the possible exception of New York, employers retain the right to test for marijuana. And let me just say that in closing, that the return on investment in drug testing is always in your favor as an employer. The average cost of a substance abuser each year is over $8,000, almost $9,000. And if you multiply that number by 15% of your workforce, which is the percentage of workers who are regular drug users, then you come up with the cost of substance abuse in your workplace. And then if you simply subtract from that the cost of your drug testing program, you'll find that your ROI in drug testing is always there. But I would say that your ROI is significantly higher if you continue to test for marijuana, because of the undeniable negative impact that marijuana has on workers in the workplace. And so with that, let me open it up, Renu, to any questions that our audience may have asked today.
Yeah, we had 4 questions. I'm going to section them off of what the topic was, because 3 of them are about the New York one. So the first question is, if an individual lives in Alabama, and I think this was about the marijuana legalization in Alabama, but they work in Florida for their company, how does that work with that law?
Oh, that is an excellent question. So generally speaking, the law where your workers live and work is the law that applies to them. So if you're based in Alabama, but you have employees in Florida, the Florida law applies to those workers. You can't create an Alabama policy that applies throughout the whole country if certain issues are treated differently in Alabama versus Florida, and they are. Alabama, as I mentioned earlier, has more of a pro-employer approach. Florida does as well. But you're going to want to make sure that you have a Florida amendment for your policy that covers those Florida specific issues. Generally speaking, as well as when it comes to marijuana. In Florida, we have a recreational marijuana law, not unlike Alabama, but a little bit different. So you're going to want to make sure that your policy has a special addendum just for Florida. And that's the way to treat this issue, regardless of the states that you're talking about.
Great, thank you. And then the rest are related to New York, but assuming testing in New York for drugs do not apply to healthcare workers, is that correct?
You know, I don't know the answer to that. I'll have to look that up. But let me tell you what I do know. If you read the, well, actually, I will come back and say I do know the answer to that question, but I've had this question before, and I understand where the confusion comes from. So there are people confused by the fact that the law in New York applies to the entire state. Whereas in New York City, they had caveats built into their law that excluded certain types of occupations from the prohibition on testing for marijuana. So generally speaking, what we tell employers in marijuana, excuse me, what we tell employers in New York about testing for marijuana is that the Department of Labor guidelines, which are online and publicly available, specifically say you may not test for marijuana. I think there's language in those DOL guidelines that creates this opening for reasonable suspicion testing. But I would leave it to this individual to read those guidelines and come to their own conclusion, but that's the conclusion that we've come to.
Thank you. On the same topic, under New York law, what about restrictions for financial institutions?
Well, you know what? While we're talking, let me just pull up those Department of Labor guidelines so that I'm not guessing on that particular question. So let's go to the next question and I will be looking that one up.
Okay, sounds good. And then we can also follow up after the call too with additional info. So are there any legal concerns if an employer tests for marijuana in New York but does not take action on positive results? The concern there is, as a staffing company, sometimes their clients have control over their drug tests, and it can be difficult to remove the marijuana panel.
So are we talking about what? Say the question again, Renu, please.
Yeah, sure. It sounds like they're asking if they are still testing for marijuana in New York, but not taking action on positive results. Are there any legal concerns?
Okay, so I mentioned before that I have 2 attorneys on staff. They're both experts in drug testing law, Randy Goddard and Yvette Baker. So I won't presume to know quite as much as they do because I'm not a lawyer. But I think it's always a bad idea to test for a drug and to know what those results are if you're not going to do something about it. In other words, it opens up that employer exposes that employer to extra legal liability if they test for marijuana, know somebody tested positive, and don't do anything to stop that individual from driving a big rig or operating a forklift, and that individual causes an accident. So, or harms somebody, causes property damage, etc. Now, that's not to say, and I don't want there to be any confusion as to what I'm saying here. That's not to say that employers shouldn't take action. I believe that you should. I think that in New York, there's a loophole for conducting reasonable suspicion testing. I've interpreted the DOL guidance, which is on my computer now in front of me, and I've come to that conclusion. Not everybody may agree with me on that point, but here's what I will predict in New York. In the same way that I predicted some other states will follow New York's example and place even more restrictions on employers testing for marijuana, excuse me, in those states, I think New York will see a lot of legal challenges to the Department of Labor guidelines that came out. And many employers will just simply not test for marijuana because they don't want to deal with the potential liability there. But I think bigger companies will look at that and say, hey, listen, we have a responsibility to know that our employees are impaired or not impaired when we send them out to conduct safety sensitive jobs. Let me give you a good example of that. The legalization of marijuana has not suspended certain doctrines of law, like respondeat superior laws and negligent hiring laws, that can be used to hold an employer responsible for the actions of their employee while operating within the scope of employment, who, while high on marijuana, harms another person or causes property damage or embezzles money from a client because they're managing their books from or whatever thing. That employer still can be held legally responsible for the behavior of that individual. What protects that employer is to be able to say, we have made a good faith effort to identify potential impairment before individuals get behind the wheel of a truck, a forklift, or managing or balancing your books for you. And we've done everything we could do to avoid and prevent that from happening. And that becomes part of the defense that employer has when an individual still, well, impaired by marijuana, does something bad. But if you're not testing for marijuana and you're not doing anything about it, then you have all of that potential burden on your shoulders as the employer. I think employers in New York should look for every possible loophole in those DOL guidance and test for marijuana when they can. The Department of Transportation, the US DOT regulations still apply in New York. If you're covered under the DOT regulations, you not only can test for marijuana, you must test for marijuana. And you must remove individuals who test positive for marijuana from performing safety-sensitive transportation functions as required under the DOT regulations. So there's still testing for marijuana taking place in New York under certain circumstances.
I'm sorry, I was on mute. Same topic. For a company that is headquartered in New York, that has a client that requires drug testing in order to work on site, but they as a company do not test. Any guidance there?
Yeah.
And then before you go on, just a follow-up from the same person. If the employee is located outside of New York and works remotely for a New York firm, how does that work?
Well, again, if we go back to the Alabama, Florida question, you must comply with the laws that apply to the workers where they live and work. So if you're in New York, but you have employees in Florida, which is much more employer friendly, then you can test them lots of different ways in Florida. There are very few restrictions on companies drug testing in Florida. And that includes testing for marijuana. In New York, you're going to have to treat your New York employees differently than your Florida employees. So that's one. What if you have a client that requires you to conduct drug testing, but for marijuana, but you're in New York where it's prohibited? Well, two things come into play. One is go back and let that client know the legal restrictions that you're under in the state of New York, looking for those kind of, I'm calling loopholes, but that's probably, both of my lawyers would tell me not to use that term, but looking for the opening for where you can conduct testing for marijuana in the state of New York. And make sure that if you're in jeopardy of losing a contract or revenue from a contract, that you have the justification, possibly the justification to test for marijuana. Now, in New York, that would apply to, say, federal or New York contracts that require testing for marijuana. I think those New York contracts, the New York government, New York City, contracts, et cetera, I think those are going to go by the wayside. Those are endangered species, those that require testing for marijuana. But if you have a private sector agreement with another company that requires you to test for marijuana, I think you have to go back and look at the law very carefully. I don't think there's as much wiggle room there as if you were talking about a government contract, especially a federal government contract, where not testing for marijuana would put you, the employer, in the position of forfeiting, the contract and the revenue from that contract by failing to test for marijuana. So, but here's Renu, I know we're out of time, so let me just say that these are all great questions. I've got 3 of them, here that I want to follow up on, and then we'll provide that information to Orange Tree, and then Orange Tree can provide it to all of its clients or those who have asked the questions. But you see our contact information there. If you'd like more information, contact Orange Tree. They'll get a hold of us or contact me directly, and we'd be happy to discuss this with you further. And again, let me just say, I'm in favor of drug testing. I think that's clear. I like all technology for drug testing, and I think there's applications for all of it, even some of the new technology that's out there. I just think the employer has to know what they're talking about before they implement a program, especially when it comes to testing for marijuana. And that's it.
Thank you, Bill. I do have everyone else's questions written down that we didn't get to, and we will follow up with you directly and reach out to Bill to provide an answer. But thank you, everybody, for joining.
Okay.
Thank you.